villages. Firstly, Badambala city. I am one of the villagers of the village Nashi Badamba. And some hooliganism, due to some hooliganism, some villagers have encroached the land of the government. For which there is obstruction of the ingress and outgress luxury. They have annexed.
That I received instruction, steps are already taken for removal of encroachment below. They have initiated the proceeding.
They have action plan already put in place. They are taking steps to recover all government lands throughout Odisha. They would be doing. We have passed orders.
The
taking that.
present application in the nature of the public interest litigation is What for? To gather an evidence? Nothing.
Item
Don't
number,
give. Don't give. What is this? It's the public interest litigations. Yes, next.
item number 2.
May
Yes.
somebody the contractor mail. Lordship can see page 17, annex to 1 mail. This is a work order issued by the executive engineer Panikuri in favor of the petitioner matter for construction of rock cell culvert on Pritipur, Dikhapur, Singhpur Road in the district of Jajpur mine. Then the Lordship kindly see annex to page 18, one agreement was executed between the executive engineer and the petitioner. For
What is your grievance?
My grievance is that the superintendent engineer is not paying my escalation, price escalation, my lord.
Is there
Yes,
any
my-
clause? Is there any clause
Yes,
for
my lord.
prices?
Page 35.
Sure.
Page 35, my lord.
Yes. Which
Contract
clause?
Clause number 31, my lord. Contract price shall be adjusted for increase or decrease in rates and price of labor, cement, steel, bitumen, pipes, fuel and other mineral components in accordance with the following principles and procedures, my lord. And Lordship kindly see annex.
Where is the formula?
My lord, that is formula.
Where is the formula which is given in 24/12/2012?
My lord, page 37, my lord, formula. They have accepted this, my lord. They have approved my
Where is this?
Lordship kindly see,
For escalation of labor is a different one.
my lord.
Then price of the goods, is there any
My
escalation?
lord, my. That
No.
is also, that is also
Where is
escalation.
the formula?
Lordship kindly see page 62, my lord.
Formula to calculate the increase in what is this POL?
Fuel, my lord, labor charge, my.
Petrol, oil and
Petrol and
lubricant.
Lubricant.
Say, my brother
My lord.
is telling you and you do not know.
My-
Labor charge. Petrol, oil and oil
Lubricant.
is a labor charge. Lubricant is a labor
I'm
charge.
sorry, petrol and lubricant.
Then is there any other component? Because
31A1.
is a
My lord,
bitumen pipes are also there, material components.
my lord.
Is there any formula?
Sir, 31A1, reimbursement or recovery due to variation in
31?
prices.
31?
35, page 35,
Uh,
31A1. That
Okay, material, cement, bitumen and all, everything is given.
VM
I got
price,
it.
price.
I got it.
Price adjustment for increase or decrease in cost of materials.
Where is your invoice or
Yes, my lord. Let's kindly see page 44, my lord. Page 44, annex to 4, my lord. The letter of superintendent engineer, my lord, to the chief construction engineer with regard to approval of the price, my lord. And your lordship kindly see page 62, annex to 5. Page 62, annex to 5. This is a letter of chief construction engineer, my lord. Lordship got it. Page 62, annex to 5.
Hmm.
My lord, with reference to above noted subject, it is to state that the schedule of adjustment data as received by your letter under reference for the above noted work is approved and returned herewith for necessary action at your end. The price escalation payment shall be made strictly as per the relevant clauses of contract, conditions of PON agreement, observing total procedures and following the works.
Then the mechanism is given that if it is done, then it will be checked and
My lord,
ensured by the divisional account officer and superintendent engineer before making the payment.
my lord. Lordship kindly see page, next page 63, my lord.
Yes,
I have submitted my bill to the superintending engineer, my lord.
yes. Then what
And
they
I
are
copy
doing?
to the assistant engineer, and your honor may kindly see the annexure, page 84, my lord. Annexure 7. The assistant engineer has recommended my bill mine.
But what about the divisional account officer?
Now that is pending before the divisional accounts officer, and in the similar matter, my Lord, Your Lordship,
To consider and take decision.
my Lord, they have admitted that they will pay the amount mine.
So that was a special case of that nature.
My 10 days.
Let's I have obtained instructions in this matter, Milord. It is under process at the level of the divisional officer, and we need 3 weeks time in this matter
For what?
for further process.
Huh?
Complete the process. To complete the process, Milord, we need 3 weeks time.
We are directing you a 4 weeks time to complete the entire process and pay the amount.
4 weeks.
The yeah, dispose of.
the nature of public interest litigation. Challenging the outcome of the-
Flagging your own personal issue.
No, Miller.
No.
I'm not a contractor, Miller. So the register industry, but I'm not a contractor. I'm not doing work.
Yes.
It should be to conduct the super special techno financial audit. The same issues pending since 2021. Or she can see annexure for a moment.
Page, I don't know annexure. It is no tagging is done. Tell us the page.
Page 1 to 3 order.
Yes.
The self-help allegation made by other companies for superficial technology, you will also can see paragraph 1, prayer for complete transparency in offline gateway. Tender in honor to rule 9B of the appendix 9 of the applicable code, volume 2, and other directives and guidelines to bring an end to long prevailing tender fixing which resulted flow of revenue in a wrong direction.
Is what your instruction?
Let's kindly turn to paragraph 4.2 of the petition. Miller. There is something to.
4 point?
Page 4 of the big petition. Paragraph 4.2.
Yes.
That the petitioner having credible information regarding occupation of and
No, corruption and misappropriation of the public.
public money in mechanical division Hirakud Sambalpur contacted another agency owner, namely Artotrana Bhuya, proprietor of Messrs. Urmila Steel and Fabrication Millet. Thereafter, the petitioner has informed by Artotrana Bhuya that the allegation raised by him has not been addressed as no order direction passed by the government to
So
conduct.
these are all on a hearsay.
Miller, no Miller.
No.
Thereafter, there is something Miller. Let's see, kindly turn to the representation they have submitted.
Which page?
That is Miller at Annexure 10.
108.
Miller Annex
108.
Page 108.
Yes.
Miller, actually here, let's see clear and straight. I'm taking a pause for a moment, Miller. What happened in this case, Miller? This Artotrana Bhuya, he lodged a complaint against that particular officer of the department in 2021 before the department and also in the Locates and the Vigilance Department. Inquiry was done by the department and inquiry report has come that he is not involved with that Miller. Now Artotrana Bhuya filed a case before the Honorable Locaite Miller. Locaite passed a direction for inquiry Miller, and that is challenged by that officer before this Honorable Court, and Honorable Court has passed an interim order. Now I am taking your lordship to the representation given by Artotrana Bhuya in 2021. That is deliberately not filed in this case, Miller, though that forwarding report is filed. Thus, that representation and this representation
Replica.
same Miller for the same one.
So there he wanted that the stay order can be circumvented or subverted in this way.
Yes, Miller. Kind.
Pay order has been taken with the OP number 5 Miller. Locate the
Sir, you know it. The moment the stay order is granted, that means there cannot be a further inquiry. You have come up for an inquiry.
No, Miller, in this cause of action, no stay order has been there. It is a order passed by the locality which has been.
Sir, what you think that we do not understand what we are saying? I think you are either purposely avoiding to answer the query, or you have no idea that what we are projecting. That the simple thing is, there was a gentleman, you have referred in your paragraph 4.2 that this gentleman has communicated to you, gave you an information that these are the things. They say that this gentleman who, according to you, gave an information to you, he approached by making a complaint. He approached the Lokayukt, making a complaint that this particular officer is a corrupt officer. On that basis, the inquiry was conducted. The inquiry officer did not find any allegation which is made by your informer to be correct. Thereafter, they again approached the Lokayukt. The Lokayukt directed of inquiry to be conducted again, which was conducted earlier by the department. Then the officer who was exonerated from all the allegations or charges, he approached the court, High Court, and there the order of the Lokayukt has been stayed. That is what he told us. Now, once you know that this inquiry has yielded, you have not disclosed anything, that he filed a complaint, there was a initiation of proceedings against the officer, the inquiry officer did not find the allegations to be true, all these things you have suppressed. Sir, you did not have anything. You derive your information from him, and he was a person who approached the court. Who are you to approach? PIL is not for that. PIL is for a person who, because of the poverty, because of some kind of inhibitions, they cannot pursue their remedies before the court of law. Somebody is espousing their cause. I can understand. He's a resourceful person. And he could not succeed because there is already a stay order. Now it will be a third inquiry order.
You have to cancel for a moment. Whatever my knowledge senior committed, I have asked the petitioner to submit some documents that the local proceeding as exonerate the petitioner is.
That was within your knowledge?
Sorry? Then why you have not disclosed?
I have got yesterday only.
Then why you are moving? Then why you are moving?
That information yesterday.
Sorry, we don't believe. Stay is still continuing or stay has been? Then you are aware? No. Conduct a special inquiry. And he's making against the ex-executive engineer.
Yes.
The same gentleman.
Same that.
Just imagine.
And the picking.
Sorry. Can you show me all these? We are dismissing with all those facts. Give us. This is something.
Opposite party number 4 is Arthatrana Bhuya in that case.
Huh?
I got it. Against whom Lokayukt have already given clean sheet.
The entire allegation is against the opposite party number 5 herein.
Yes.
And he was a person, this gentleman against whom all the allegation was made by him.
Yes. That means, see, I have folded the relevant portion. That means, see, page 19 here. That is the same representation. Page 19.
Prior to Lokayukt, the department has already initiated a proceeding.
Let's see, yes, Miller. Let's see, kindly turn to page P90. P90, the inquiry report is at page 392. 392, Miller.
Oh, this Arthatrana Bhuya approached this court by filing a writ petition.
Yes, Miller, earlier.
And the writ petition was disposed of directing.
Yes, to conduct an inquiry.
That was disposed of.
Yes. Thereafter, inquiry was conducted.
He was given clean sheet.
Yes.
So he was-
And then that gentleman did not challenge that inquiry report.
But in inquiry report, he has given a clean sheet. Miller.
Correct.
After
But that gentleman did not challenge the inquiry report.
No,
He did not.
no.
Then he approached the Lokayukt.
Lokai. And this, Miller, this Arthatrana Bhuya, let's will find there is a FIR, he's a gangster. The FIR is there, Annex 1. in that.
It is which I will be doing it.
I will look at it.
Yes, aware. Your client is more intelligent. He has suppressed many things from you. Don't worry. Let him pay the cost.
Item 4.
Lakshmi,
Let him pay. You are not going to pay. Is a litigant who is going to pay. Why you are?
Item 4 minor in portion manner.
What?
The petition was placed for to open the service of his subsidiary manner. In the meantime, the government has
What?
given the letter manner. Manner.
What is
The sub-register office already open manner as per government notification manner.
Have you read it?
Research subsidiary office.
Representative. We're requesting you to set up sub-register as well as sub-treasury office.
Hmm.
That is,
These are the
clear and
pendants of the
that
state,
is the
no?
representation he has given.
The government.
Why it should be?
For establishment. You want the government to establish two offices in your village,
Set up, already open manner.
already open, then,
Open manner. So this nothing.
then your grievance is redressed.
Partly redressed. Man, the petitioner then declaration man come to page 13. Petitioner press to open the subsidiary office and sub-register office. In the meantime, already government has opened the sub-register office. During the pendants of the year.
Who is he?
Reshapes man subsidiary office.
Who is he?
No, who are you? Why are you exposing the cause? Who are you?
I am an advocate on behalf of the public. Can you advocate on behalf of the public matter?
Advocate means?
On behalf of the public.
On behalf
No,
of public.
you are an advocate or what?
Man,
What's your name?
Pramod Kumar Raut, man.
Yes. How can you write as an advocate? As a deponent?
Benefit of a public matter.
You can write that you are also in the profession, but how can you signature? You can write as an advocate designation. Which page?
The Lakshmi see. Page 311. 311, and it's the 6 minor.
Yes.
This is a proceeding.
No, where is the-
2020.
Where is the ultimate decision?
Yes, ma'am. This is a proceeding of 19/8/2025, my lord. And the 312, the decision taken. The Lakshmi see.
This is the 19th August and 20th August.
Yes, madam.
Then which one
Madam,
you are?
I am.
Your name is shown where?
Madam, 313, your Lakshmi see.
Huh?
Everywhere I was a tenderer. Serial number 2.
What's your name?
Devi Prasad Mishra, madam.
Devi Prasad. So you are in a
And SL
Dasmantapur block.
10 month of block.
Rejected. Then
My tender has been rejected.
Kudra.
The ground has been.
Kundra.
Yes, Kundra, Mandapur. Then my lord,
By Pargura.
Potangi,
Potangi.
Guda,
Huh.
Koraput and Jaipur. In all tender. Then
What is the ground?
ground of rejection is that I have not signed the tender in each page, my lord, and the digital signature has not been put by me.
Huh.
I have given an objection. One person, namely J. Central, has not signed the digital signature.
But JS Enterprises is also rejected in
Yes, ma'am.
Potangi.
only to accommodate those costs, him, the same has been done. Your Lordship may see, I have annexed the document which I have submitted.
Which in relation to what?
By your Lordship may see, page 95.
Yes, I find JS Enterprises, Dasmantapur, his was also rejected.
Everywhere.
Kundra rejected.
Yes, ma'am.
Nandapur.
Yes, everywhere it is.
So Narayan Patna rejected. So what?
I have put my signature everywhere and also I have signed digitally. I have given a sample paper.
So why you are taking the name of JS Enterprises? I'm just.
To accommodate him only because I have.
But these applications or bids are also rejected. What to accommodate him?
Because
If his is accepted.
now the fresh tender has been called for.
So
On 31st, the fresh tender is called and first this proceeding has been uploaded on 1st of October, November, my lord. Your Lordship may see the uploaded that. No signature is there, my lord. Uploaded, your Lordship 315.
And subsequent tender, he was allowed.
No, not yet finalized. The tender is
So
not.
you also participate.
My lord, because
It appears that most of the tenders, their tender bid was rejected. Everybody is rejected.
my tender is in.
What is your instruction?
Receive instructions, my lord, but page 315, my lords, only apart from three, all other tenders were rejected, my lords, and it was decided to proceed for retender. Accordingly, a new tender notice has also been for my lords at page number 219.
Oh, that means out of this, only 3 units where more than one were found.
My lords.
Correct.
Yes, my lord.
And rest, everybody's tender was rejected. So they wanted to float it.
Yes, my
My
lord.
lord said the ground they have taken that is not correct. I have given the tender I have submitted, which I have downloaded from the website also.
No,
I have signed each and every page and also digitally signed each and every page. That is not the ground. Only to
If at all
No.
accepted, it will be single tender.
no, my lord. I have filed 3 writ petitions. The second one is everywhere he has also participated. He has also signed and digital signed everywhere.
you probably could not get my brother says. Suppose your tender or a document is accepted, then
Yes.
also you will be only a single bidder.
No, my lord. Others are there.
Others they have rejected, they have
The
not
second
come.
one, second
What he says-
matter is SL Care Associates. He has also signed.
Attached some other writ petition.
Huh.
They are also there, they should not have been rejected.
Yes, ma'am.
Because they have filed also digital. So this rejection is totally absurd and arbitrary, that is what he is saying.
But this fresh one has been
Uploaded.
uploaded.
Again participate. What is the harm?
Your Lordship may see the second tender has been floated on 31st before publishing this list also. Your Lordship may see that is press 315, my lord.
So what is the outer date?
My lord.
What is the outer
Today is
date?
the
to-
opening date of that tender.
So you have participated.
I have not taken any instruction because
Then
it was last date was Saturday and
So
today
what
is
can
date of
be-
opening, my lord.
what can be done?
My dear Lordship may see it is down
Process is already on
already.
1/11/2025 at 12:22 AM, my lord. This the tender, your Lordship may see, it has been published on page 218 on 31/10/2025.
Much after the decision was taken on August,
No, my lord, it is not
19th
taken on
not 20th August, maximum 2 days the meeting was there.
No, my lord, it is not on August. Your Lordship may see. Nowhere it has been, date has been put, my lord, when the decision has been taken.
He
They have
he has
taken
gone, he has
Sir,
gone.
what is the contradictory material that you can produce that it was not in August?
I have given an objection in August, my lord. If the proceeding is 19th, then how they have taken consideration of my application on 24/8, which is my objection.
What?
My lord, this proceeding has been drawn, they are saying in 19/8 or 28. Your Lordship, middle portion, your Lordship, see 312, fourth para. In the meantime, email communication dated 24/8/2025 were received by ADM from some complaints enclosing copy of judgment dated and rejection of all bids which have not been digitally signed on each document citing the aforesaid order, my lord. Thereafter, they have taken,
No, there may be something else. I do not know.
my lord. My lord, your Lordship may say, no date has been there in page 315. Rejection of tender on the basis is not correct, my lord. No date has been put, my lord. And for the self-same document, my lord, I have been declared as qualified in respect of Boriguma block. Devi Prasad Misra.
This decision was approved, saying that the financial bid shall be opened on 6th November. That
There I have been declared as
that was
successful, my
that was taken
in one year.
perhaps on first November 25.
Actually, no, 2025 is, I think, is the wrong one, or 24 is the wrong one. See, because the judgment of 2/9/2023 is 2 years before. They wanted to cite it.
These are all something. You see this one.
No, signature is digitally signed by Manas Ranjan Mahapatra.
So that is from the collector's office. That is 1st November. Here you see, here this one. At this end. So financial bid shall be opened on 6th November.
6th November.
Some document, my lord, I have been selected in Boriguma, my lord, Devi Prasad Misra, I have selected, my lord. If I have not signed the document, for one they have qualified me, the others, all 6 units, they have disqualified me for the self-same documents, my lord. Self-same documents I have scanned everywhere, my lord. Everywhere I have scanned, I have filed for that reason, it is bulky one. I have filed the documents which I have scanned, my lord.
So that also shows the fairness on the part of the authorities. If the authorities have found you qualified in some of the matter, some of the law, how there was no reason for rejecting in respect of the other block. Had they any kind of a bias against you, they would have rejected everywhere. They would have rejected it. May not have allotted. He may not have allotted the work for one block.
Because here the JS Enterprise is not a party, my lord. For that reason, they have allowed it.
No.
And they have not put the date for that reason, my lord. They have protected the tender, flash tender on 31st.
Even all these three, the JS is not there.
No, my lord.
All these three, JS is not there.
JS in one. In my case, there is not there.
No, sir. I do not believe that, because 3 units they wanted to continue.
Yes.
In 3 units, in one of the unit in Lamtapur, You have been declared as a highest bidder.
No.
Qualified?
In Lamtapur, my bid has been rejected.
No, sorry, in Borigumma.
Boriguma, I am qualified.
Qualified. And must have been awarded the work.
No, 611 is the date, my lord.
611.
Yes, that is not with me. Sorry, my lord. 611.
So you have been, and GS is not there.
No.
Here in Lamtapur,
JS is there.
GS is rejected, sir.
He rejected because he has not signed anywhere. my lord.
Nothing.
He has not signed anywhere. my lord.
So he has been rejected. That's
Madam.
anyhow.
Yeah, if your lordship, they will produce a single document to show that I have not signed the documents, then I will be saddled with God.
Why the court will use its powers to find evidence,
No, my lord.
to gather an evidence for you?
No, madam. I have
Nothing.
attached all the documents. If your lordship will see the documents page 95 to onwards, the tender documents submitted by me, everywhere I have signed and digitally I have signed. Not that I have not signed digitally, my lord. Your lordship may see page 95 onwards. Everywhere I have signed digitally and also signed personally also. Annexure 3, my lord. In respect of one block I have given, my lord. Your lordship may see. Everywhere I have signed. Not a single page left out, my lord.
What is this, madam?
If I may refer to the same document, my lords, and in the first box, my lords, at page number 314, serial number 7, my lords. Here, petitioner has participated, my lords, Devi Prasad Mishra, but there is no JS. The allegation is that he's to give biasness to JS Enterprises. JS is not here, my lords. Similarly, serial number 9 also, JS has not participated in this.
No, I'm just finding it out. I'm just finding it out, page 95. What is this? It's a tender document.
95 is the tender which the petitioner has submitted, my lords.
No. Is a notice inviting tender where he has said it is simply he has copied it and then submitted.
Yes, my lords.
So how could it be signed by him?
Digitally signed, my lords.
How? Why? You have floated a tender. He has to fill up and then give it. But this is what is a tender document which he is giving, which you have floated. He is not supposed to give that tender document.
Also, I have signed everywhere, digital signed.
How could you?
That is the requirement under the.
No, madam. The
The
requirement.
tender document is to be downloaded, means the tender where you have said last date, initial date, everything is to be downloaded.
Page number 21, my lord.
I am asking 95.
Yes, my lord. As per promise of the tender, only all documents have to be digitally.
Is this a form of a document?
Other documents which the petitioner has submitted, it requires that digitally signed. All
Probably
documents
is
need to
not. Have you seen 95?
Yes, my lord.
Can you please come to 95? Both of you.
Yes, ma'am.
What is this? Read. I'm unable to find. Please read. What is this?
Put to the inviting tender, my lord.
So is it should not form part of the bid. Only thing is, if there is any requirement, they have to punish the information on the right hand side column.
Yes, my lord.
But it does not require anything. Then,
My lord, for
and why it is digitally signed? I'm really surprised.
the petitioner's document, my lord, which he had submitted, my lords.
And this can't be a condition.
The condition is that.
The
all-
condition is
1.4.
97 onward. I can understand.
So the 313,
That is
there
also
are
digital signed.
two grounds on which I think they have received.
Your lordship may see
I got you. Thank you. No, there are two conditions.
Yes, ma'am. I have
And
fulfilled the condition, your lords may see here also.
no,
Each and every documents I have annexed and also I have signed those documents. And 97 onwards, for that reason I have given it. Otherwise, I should not make it bulky, madam.
anyhow, they have floated a new tender. So, what is the last date?
Today
Today is the date of opening of the
Go,
application.
go, go.
But let us take instruction, madam. If they will say anything else that I am ineligible.
Then I will impose a cost.
Yes, madam.
No,
If I have received the or signed the document,
it appears that
Under Annexure 1, my lord, for the period of 5 years.
For release.
is there any provision for extension?
There is
Under
no-
what provision of law?
There is no provision for extension.
Then-
And what I humbly pray is that after the execution of the query list in the year 2021, the rule says that prior to the execution of the query list, there has to be a mining plan pre-approved, my lord. That is rule 28 of the rules,
You,
Odisha Minor Minerals Concession Rules 2016 minor. Rule 28.
yes. Yes, what it
Mining
says,
plan as a prerequisite to the grant of query lease.
where
Rule 28.
28 is contains many sub-rules, which
Sub-rule 1.
one?
No query list shall be granted by the competent authority unless there is a mining plan prepared by the recognized person. And
Correct. No, it has not been done.
initially it was not been done. Initially the lease was executed in my favor. On
That was wrong, contrary to 28. So we will be declaring that it was contrary to 28(1).
Thereafter, the mining plan was modified and it was approved in the month of February 2021. Thereafter, I submitted the same to the State Pollution Board for obtaining consent to operate order. And that was granted to me in the month of September of 2021. For that first half, I could not operate the query list. Thereafter, I started my operations. Thereafter, the modified mining plan, which is under Annex 2, that was prepared and approved for the period of 5 years. And what the operators have done, without issuing any notice or without intimating, they themselves have renewed or modified the mining plan, and they approved once again under Annex 4 on 2nd of April 2025.
What is this page?
Page starts from page 63. That is the renewed modified mining plan for the period from 1st of April 2025 to 12th November 2025.
Yes.
Pursuant to that mining plan, and to again apply for the consent to operate before the State Pollution Board, which I have done in timely, and the order was also granted under Annex 5, my lord, page 86. But there was a stipulation in that consent to operate order, my lord, which states that for blasting I have to acquire necessary permission from the competitive authority, my lord.
Yes.
Complying with said condition, I submitted an application under Annex 6, my lord, in the month of June. Page 92. In the month of June, my lord.
2025.
June 2025, my lord. But the competent authority, who is opposite number 3, granted me permission in the month of October 2025. That is 1 month prior to my expiry of the lease. And because of the delay in 4 months, I could not operate my lease, and I could not extract the stone quarries. But there has been a
Claim and damages.
development.
Claim and damages.
And there has been a development after the filing of the writ petition. I've made a recommendation under Annex 8 with the opposite party number 2. And opposite party number 2 and 1 on receipt of the same has forwarded my grievance to opposite party number 3 for opposite party number 4 for my detailed inquiry. Opposite party number 4 has given a report, my lord, which was filed by way of additional affidavit. Yes.
Where is the additional affidavit?
Just now.
That is in the month of November. This subsequent event in after filing of this writ.
Yes, ma'am. After filing of the writ.
In the month of November.
Yes,
recently.
10th of page 5 is the forwarding. Page 5 is the additional affidavit. It was forwarded to the Deputy Director of Mines. Page 6 is the report, my lord.
The lessee could not be able to operate the quarry for 4 months, from June to October.
Yes, page 7 is the relevant portion. May I place that the relevant portion?
So let them take a decision. What more?
They have admitted that there have been lapses on the part of the company.
No, there is not an anyhow.
Page 7.
Then what about page 6, 7?
Page 6, 7 is the report that has been submitted in compliance to the Annex 9 model.
Now permission is obtained, blasting permission.
So it has been said that if you pay the entire money, if necessary permission may be issued to the lessee on his merit for extension.
All money has been paid, ma'am. That is.
I do not know. This is what is the last line.
Yes, ma'am.
Clause E.
Yes, ma'am. Since there is a.
It says that if he pay, balance quantity is 436.000 cubic meter to be extracted from the such and such. for fuller utilization of the approved quantity,
Yes, ma'am. And
for which the royalty and dues have to be paid.
has been paid, madam.
Hmm.
Has been paid.
So let them they will take a decision what we can do.
But 900.
So this is the case of a consideration of report. You have asked for extension. You take a final call whether to extend or not to extend.
The director of minor amendment.
Sometimes there are some good cases for representation.
So has already been paid. Then what is the hurdle?
Has been
for
paid
you?
from the start.
What is a hurdle? Everything has been pointed out.
They have
Approved quantity of stone for which royalty and other dues has already been paid.
Yes, madam. Here the representation was only for 4
Uh,
months. Petition.
You should have-
After taking in
one.
disposed of.
The writ petition is out 13 months extension, but the representation which he had given is for 4 months.
Whatever, we do not want the deputy director mine says that the remaining balance quantity of 436. I have said on the light of that request having made, that's all.
And the decision has to be taken by Director of Minor Minerals.
I have said, director. Minor minerals, he has written it on 13/11.
Yes.
Please look at it.
No, which is the summer command.
Lordship may kindly look into the date of order. After time barring, they have come in this writ petition. And I don't think anything allegation.
They are challenging the order
Annexure 3,
Actually, 3.
dated 20.
passed by.
Assistant Commissioner.
What is this?
The writ petition, that the order has been passed on dated 22/10/2024, and the writ petition has been filed on 16th.
How can you
2025.
rely on this? You have corrected 28th February 2025, and the writ petition was of 25 in this case. So in your case, it is 24. You are challenging on 25. How can you equate this case with your case, sir?
The order passed in that.
Mr. Counsel,
No, and is there any
when
explanation?
the other petitioner came within time provided in the statute,
Not a single.
we directed like this.
Where is explanation?
No explanation.
Then
This sharp practice you should
no.
Apologize, Your Honor.
No,
don't apologize.
brother, on the ground of delay and laches in absence of any pleading, reject.
This may be tagged along with the badge.
No, nothing,
On photo.
nothing.
No, sir.
Yes, next.
Item 9.
But cancellation of Huh? Where is it? What, that is not applicable. Why are you keeping it in your record? Don't do such type of sharp practice.
Yes, cancellation. Yes, cancellation
Dismiss.
on the ground of delay and laches.
Delay.
Next.
Item 10.
Cancellation.
RC cancellation.
Item 11.
Also, I have received just now the copy has been served.
You may call it next week. I'm sorry for the inconvenience.
Yes.
Subject your lordship can.
Since the copy of the writ petition has been served upon
Same position.
Right.
Let it appear in the same position.
yes, as item number 11.
No, not.
Yes, same position as item number, maintain item number 11.
No, sir.
What?
As a fresh matter, I meant as a fresh matter.
So obviously, next.
Item 12.
Item 12, Your Lordship.
No, that's the problem. It was served on the wrong office, my lord. So as item number 11 is concerned, not to my learned friend.
Item 12.
Item 12, Your Lordship. My learned senior Mr. Kaur was supposed to argue this matter.
Autonomous jurisdiction, they should not now.
Sorry, Your Lordship.
Who is your senior? Who is appearing?
My learned senior, Mr. Kaur, was supposed to argue this matter. If
But
it
he has
can
not
come.
been briefed. He says he's not.
12, item number.
Item number 12.
It is.
I was,
Mr.
I
Martola-
think we have to take some more instructions because.
Yes.
No, you are not engaged.
I'm not.
So why you are taking a name of the senior when you have not formally engaged him?
Mr. Madhavlal Agarwal,
Miss-
Why?
my learned.
Sorry, Your Lordship.
Why you are taking a name of a senior when you have not formally engaged as it? Because he says you must have approached and he wanted certain more clarification or documents to be given. It does not mean that he has accepted the brief as of now.
Madhavlal.
And adjournment on his ground. Why the adjournment on the ground of a senior? 2 weeks.
Item 13.
May I please, Your Lordship? The annexure one is the informed order law, passed by another single judge, wherein your direction has been given to.
Sir, with deepest of respect, I am not very much conversant with this annexure theory. Just give me a page number. That's all. I wanted a page number. That is more convenient to me to come. This is page 7.
Page 7.
Yes.
Blood, wherein blood.
Just 1 minute.
Even.
Give me 30 seconds time to hurriedly go through the order. Sir, how can you, after you admitted that you will pay his retirement dues?
That is my summary. That I have not admitted. It is the respondent number 2 here, the union, who is the respondent number, opposite party number 3 to the petition.
And go before the single bench and point out that it is not my admission.
Yes, ma'am. That I have stated, Lord.
No.
Affidavit has not been taken.
We can't go by the, because the record says on 1/1/2022, the court says.
Yes, ma'am. That is the respondent number 2, who is a separate entity.
No, the impugned order has been passed on 1/1/2022.
Yes, that by the respondent number 2, who is the respondent number 2 here, by the union. I am the appellant is the federation.
But the court has recorded is a clear admission on the part of the authorities that petitioner is entitled.
Respondent number 3, opposite party number 3, here the respondent number 2. That is not my admission. Let's kindly see that document. I have annexed here.
Ramdas Naik case will apply.
That is what I am talking about. AIR 1982 Supreme Court page 1437 or something.
You have to go before the same court.
You have to go to if there is a wrong recording of an event, then in that event you have to approach the same court and point out that this is wrong. Appellate court was not there. Appellate court how? The appellate court will go by this. In Ramdas Srinivas Naik judgment, which is commonly known as A.R. Antule's judgment, there the Supreme Court says that nobody can contradict what has been recorded in the judicial order by the court. If you say that there has been something, then you will have to approach the same judge and invite his attention that this is the wrong recording. We can't. Find out that judgment of Ramdas AIR 1982 Supreme Court, page probably 1437 or. You can't do it, sir.
Despite my oral submission, my counter affidavit.
Sir, I appreciate every bit of it. We are not denying that what you are saying is incorrect. But the approach to the appellate court is, to some extent, is not a proper forum because of the judgment of the Supreme Court.
But now, because of that recording only, I am facing content.
Sir, that's why you have to find out. You have I would say, the remedy, but you have exhausted the wrong remedy. What can I do? What can we do, rather?
person observed that way, I will approach.
What observe? That's the judgment of the Supreme Court, sir. It's the bench who has to give you.
Person observed in the lordship.
What observe?
This is
sir.
contempt proceeding I'm pursuing.
No, no.
Because of this, because of this only. And my oral submission that I have not pursued.
Where is the judgment you find out? Come. State of Maharashtra versus Ramdas Srinivas Nayak.
It is 1249.
I was 1437. I was thinking 1239.
1249.
49. I jumbled up the numerical number. 82. The instant appeal is filed
Lordship's one line of.
Sir, I tell you, the court cannot usurp the advisory jurisdiction that what to do.
But I know, that's your.
Now, I have already recorded the judgment of the Supreme Court, quoted the line. Now you have to think that what is there.
But in fact, my counter affidavit, that has not been adjudicated, my lord. My counter affidavit where.
Please read this judgment. I would be very, very happy and humbly beseeching you to read the judgment. Please, I think that will give a clarity in the mind. There is no difficulty. Please.
Item 14.
Yes. What is the impugned judgment? Which page? Impugned judgments. Everybody is following this, na? Say you may next year is more, but once you follow the hard copy, then. What is the matter? What is the judgment?
Judgment is looks at as page 458.
Yes, what it says.
So actually, this is an application that was filed in order 21, rule 97. Read with section 151. Read with section 47 of CPC.
Oh, all.
Challenging the execution court's order
Where?
before the Honorable High Court in writ jurisdiction.
How writ lies?
Well, that is the argument that was made. The Honorable Court said alternative remedy do not prohibit the High Court to entertain.
How? High Court cannot be converted into an executing court.
So not only that,
And
Full bench decision which is confirmed.
yes, but contrary to law, what I do not to make any submission. If I also go to the judgment with due respect, but the law has been kept in one part, judgment has been passed.
who is appearing for the other side?
I
think Mr. Mitra is appearing along with us, my lord.
Along with you?
Yes, along with us, my lord.
Do you have to say anything, Mr. Mitra?
Well, I have not come across a matter in which Article 226 has been taken recourse to, challenging an order under Order 21, Rule 97, read with Section 47. Well, the issue of fraud had been gone into on a writ application. It had been held that there had been a fraud had been perpetrated, and the order had been order of the district court had been set aside.
400?
61. 462.
Yes. The very 450.
Well, this is something, well, I have not seen, I have not heard. And your lordship has got enormous experience in civil matters. I am sure your lordship has not come across a case where Article 220, the writ petition has been filed for the purpose of assailing an order passed under Order 21, Rule 97.
Most famous judgment on Section 47 in a recent time is, which is delivered by the Supreme Court. If a person with such a name could not succeed in the Section 47, whether the person of this name will succeed on a lighter side.
Your lordship will kindly come to page 500.
What is a very apt judgment on 47?
But in fact, the recent judgment that your lordship is talking about, my lord, that is
the old one.
Raman versus Rajamani.
No. That I know is the old one.
The two Calcutta High Court judgments.
You could not understand what I mean. There is a celebrated judgment of the Supreme Court where the petitioner his name was Dhurandhar Prasad Singh. If you could succeed in 47.
I will request, I will request your lordship to come to page 500, paragraphs 51, 52, 53. Lordship will kindly look into this
I
paragraph.
understood, Mr. Who is for the other side?
That's the first time.
Interference. Set aside.
Yes.
47 allowed. 47 allowed. And order 2197 dismissed.
No, no, allowed. All allowed.
He tried to open everything.
But the award of the arbitrator, which has been set at rest, has been set aside here.
Under the National Highway Authority Act.
Well, I shall tell you, Lordship, my lord, so far as the award is concerned, award had also, my lord, has been approved by the Supreme Court, and my lord, Supreme Court directed in an order that the amount is to be paid, released within a certain time. Well, now this judgment which has been passed, this impugned judgment, in paragraph 50, 51 onwards, that award has been set aside, appropriate disciplinary proceedings to be taken.
Mr. Mithru, you know, there is another case there in the Calcutta High Court where the appeal was affirmed up to the Supreme Court, but ultimately the execution stage, it was set aside under section 47.
Can be done. Can be done.
So
But,
that can be done. There is no difficulty.
No, but then again, my lord, order
Can be done. But anyhow, notice what stay? Nothing. It has gone. If we stay, then it will revive.
So this is direct collector to make an inquiry. Inquiry.
Where is that direction?
Page 500, man. Page 500.
Paragraph 53.
Paragraph 53. The collector gives a direct to cause an inquiry.
Issue notice. Court dismissed the writ petition anyhow. Then thereafter,
But then the execution case was filed by us for enforcement.
before,
The district judge came here.
that is what I'm saying is a section 34 court.
Yes.
I said
No,
that
execution.
is what.
No, not section 34.
Then who can execute? It's a 34
Yes,
court.
34 court. 34 court.
No other court can because of the issue, because of the definition having assigned to the court.
Yeah, no.
No other court.
And then when the matter was pending.
And who takes up section 34 here in this state?
District judge.
Hmm?
The district judge came here.
Huh? Are you sure?
Yes.
Or
I'm sure that.
or a civil judge senior division?
No.
I heard.
It was prior to this Commercial Court Act coming. By the district judge, when the matter was pending for execution before the district judge, they filed an application for modification of the
It is
award.
only under the Commercial Courts Act it is going, or normally it is going to civil judge senior division?
Under the Commercial Court Act is go to.
I understand.
Yes.
Under the Commercial Courts Act is different.
Otherwise, district judge. That's the principal civil court.
Anyhow, so they went to section 34 court
Yes.
for execution. Then
So there, this section 34 court passes an order that this amount be deposited to the Minister Competent Authority.
that is under section 37, 36, the execution was
Yes,
paid.
exactly.
Yes, then
But there was a prayer by the Competent Authority that the award is not correct because the arbitrator was the arbitrator for National Highway number 6 and National Highway number 215. That having been rejected, the matter was carried to this honorable court. This honorable
no.
court
I could not understand. You went for an execution.
Yes,
Of an award.
yes,
Correct.
correct.
Then in the execution, what you said?
In the execution case, when the Nane district judge directed for the deposit of the amount, instead of the
Deposit by whom?
deposit by the National Highway Authority, National Highway Man.
Correct.
By the
The award is passed against you.
Award is in my
No,
favor. But our land has been
You are?
acquired.
The award holder.
Award holder.
Yes.
Yes, with the award holder.
Yeah, you put in. Then who came? The authorities they came. National Highway authorities came.
National Highway filed an application.
Correct.
Award cannot be executed because the arbitrator is for the National Highway number 6 and National Highway number 215.
Yeah.
And since there was a mistake with regard to 6 and 215, it possibly could not be executed. They moved an application that having been rejected by the district judge.
Means literally objection under section 47 was raised.
Then also, literally,
It cannot be executed. There are three things under 47. Execution, discharge and satisfaction.
Yes.
Apart from that, it's section 47 cannot go. So once they put a question on executability of a award, that means section 47.
yes, that was rejected.
Yes,
Then they came to this honorable court.
correct.
This honorable court said that under section 33 of the Arbitration Consent Act, that correction could be made that 215 could be made 6. So it allowed the application. Then we went to Supreme Court. Supreme Court set aside the judgment of the High Court, restored the order passed by the district judge and directed for the execution to happen in accordance with law. Then thereafter, when the direction for them to deposit the amount, the National Highway Authority again filed another application. When the Kala was directed to appear, they filed. That is
Authority on the Land Acquisition
in
Act.
short, it's called Kala, CAL.
I understand it's a black, so that's why I just I was.
Land Acquisition Act.
That is a competent authority. Well, when the amount that did not get deposited, the district judge directed that the competent authority should appear for the purpose of examination. That the challenge before this honorable court. This honorable court dismissed that application. Thereafter, again, when there was a direction to deposit ballot, then National Highway Authority moves an application to the project director by saying the project director ought to be added as a party. That having been rejected, they again approached this honorable court. This honorable court rejected that. Against that, they went to Supreme Court. SLP also dismissed.
And the Supreme Court directed to dispose of the execution case expeditious. Then they filed 47.
And thereafter, the ladies of opposite parties, the respondents 1, 2, and 3, whose land were sold to another scheduled caste, from whom we have purchased land. And those ladies, much after the entire land acquisition process was over under the National Highway Act, moved an application under order section 47, reduced order 21, rule 97, 101, to set aside the award.
How two can reconcile? A person who can file a section 47 cannot file under order 21, rule 97, 98, 99, and 101.
That's what they did.
How? And those who can file order 21, rule 97 to 101 cannot file because 47 is a judgment debtor or a representative or person claiming under the judgment debtor, then it's he can. Otherwise, 47 does not lie.
Lordship, just see page 181, application and order 21.
This is the petition they filed.
It is at page 186, madam. The prayer is
page 181.
The award passed by the arbitrator in favor of the present appellant, decree holder be set aside. This is the prayer in the order 21 application.
No, that order 21 is the adjudication of right, title, and interest. All question relating to right, title, and interest that can be gone into by an executing court because there is an embargo created that fresh suit does not lie once the decree is passed.
More importantly, how can a rule 97 application not stand in a
97 principally it is with regard to an police help. I understand, but 97 also talks about that if the process server or a bailiff, as we call it, is prevented by any one person from execution of the decree, then the notice has to be given to that person why he is obstructing. So that right is also created. So he perceived himself as an obstructor or a resistor. And then 97, why not?
My Lord, if I may just...
Quaternion principles can apply.
No, my Lord, I tell you, Lordship, my Lord, you kindly come to page 181.
Anyhow, we were just recording some facts to issue a notice for the purpose of...
and kindly say the operation of the order. Yes.
Interim order.
Well, Lord, kindly, two things I just wanted to mention. This order had been passed in a writ application, my Lord, in respect of an order passed under Order 21, Rule 97. Just kindly see the prayer made at page 186. This is something which is something I have never come across. In a Order 21, Rule 97 application, the prayer made is, hence it is prayed that the award passed by the arbitrator cum collector in favor of Dilip Kumar Poti, the decree holder, opposite party, be set aside. When, my Lord, admittedly, the application for setting aside of the award had been dismissed long back. It had been dismissed and then it had been confirmed by the High Court. Now, again, this prayer has been made in Order 21, Rule 97. My question is this, on an application of this nature, could an order have been passed, the impugn order that has been passed, on a writ application? The order is award passed be set aside, and kindly see the order which has been passed in Order 21, Rule 97 application. I am questioning the jurisdiction of the court. I am saying that this order could not have been passed. Paragraphs 51, 52, 53, 54. These paragraphs at page 500 are totally outside the purview of Order 21, Rule 97. No evidence had been taken. My Lord, under Order 21, Rule 103, appeal lies. There is a provision for appeal. How can...
Because of Rule 103.
Yes, kindly see that.
Deemed appeal.
Yes. This is...
I'm sorry, deemed decree.
Well, I am submitting to your Lordship, kindly may not say the operation of this order, my Lord, until your Lordship hears out the appeal. The appeal needs to be heard, and my Lord, the law has to be set down as to in what proceedings what kind of procedure is to be adopted for the purpose of pursuing your right under Order 21, Rule 97. This is not, I respectfully submit, this cannot be so. This is totally contrary to the Code of Civil Procedure. This is contrary to the Constitution of India. How can this order be passed on an application where, my lord, the order had been asked for setting aside of the award, which has attained finality long time back?
Sir, what is normally done under Order 21 or 101 for declaration of the right title and interest, and that the judgment which is sought to be executed is not binding on him.
Right. That's the thing.
But he has asked for, and he has said that for this kindness I would ever pray. So I do not know.
Well, I submit to you, Lordship, this is something which is on the 23rd of August 2021, this Honorable High Court dismissed the writ petition challenging the order which was passed by dismissal under Section 34 of the Arbitration and Conciliation Act. This attained finality in 2021.
Mr. Mitro, we were proceeding to dictate the order of staying the operation of the order.
Yes. Yeah, Lordship, can you tell that?
When we wanted to record the fact, then your advocate and record intervenes and says, no, this is not a true reflection of the facts.
No, the facts are there.
Don't worry. So that is what we really wanted.
Lordship.
So many facts you have said, we have half of it has gone miles above our head.
No, I respectfully submit to your Lordship, it's a short matter. My Lord, will you kindly, my Lord, look at page 116, where on this Honorable Court had been pleased to dismiss the appeal at the writ petition, which was filed by my Lord, the respondent.
We appreciate, Mr. Mitro, we appreciate.
Yes.
There is no difficulty. We know whether the writ court can convert itself into 47 court or Order 21, Rule 101 court.
Or a suit court. This is really converted its suit court and held. Mullah, is a fraud and everything else has been held here, and then this order has been passed.
This can also be because the fraud needs to be proved. The particulars of the
quite absolutely.
They have to lead an evidence without
absolutely
cannot be done.
Nothing was done, and
So
this order.
We appreciate what we have said.
Yes.
Lordship, item 8, Lordship, I apologize for my mistake, Lordship. Deeply apologize, Lordship.
Thank you, sir.
Where is the improved order?
Page 87.
There were a separate category of the seniority list,
Yes, ma'am. The page
or is a common,
common gradation. It's common gradation.
no, why the first paragraph, which is I'm really concerned with,
The Lordship is
that whether the senior reserved category employees can be denied promotion to the higher post under the unreserved category, ignoring their seniority. That's why I asked
Yes.
whether a separate seniority list or a gradation list is prepared, one for reserved category and one for unreserved, or what?
No, ma'am. One gradation.
One. That's why that should be, that's why
Yes,
I'm
that-
asking.
That is the, yes.
What the single bench has done?
No, single judge has held that there's Lordship. States, conduct will matter.
It is found that the method, the procedure which is adopted was wrong.
Yes, ma'am. Only I'll draw my notes, look at the root and the prayer. And during pendings of the read petition, 4 promotions have been given. And our juniors have been promoted in the meantime on the reserve category. And 3 respondents, those out of 5 petitioners who have different on single judge, they have been also promoted.
But you have been reverted back to the feeder. That is
Yes.
what I
Yes.
find. I
Yes.
find that troubles me
Yes, that
as well.
because in
Because once you have been promoted, then the next promotional avenues which occur, you were not allowed to participate. Had you been allowed to participate, you could have.
yes, my lord.
I understand.
Yes.
I understand. This is what you wanted.
Yes, ma'am.
Who is for the other side? How can this be done in that way? Reverting back to a feeder post means he is losing 4 avenues of the promotions.
But here, what has happened, this case dates back to the year 2019.
I understand, sir.
Wherein, my lords, the promotion was made subject to result of the application. That is also noted by
No, I understand, sir. Suppose if you are quashing the promotion, the problem is that since he has already been promoted to a promotional post, then the next the exercise of the promotion, he was an eligible candidate in the feeder post. He could have been. But since he is already occupying a promotional post by giving a promotion, he did not participate, he could not.
That is one aspect which you are also.
So how in a service jurisprudence, then what are the modalities that should be adopted?
My lord, yes, my lords. I will take your lordships to one simple thing that
Whether this
first, but this is a case for promotion from
in the various read petitions. Let me be very clear. I am a
What
caveat.
has happened to the other read petitions?
Those other read petitions, my lord, your lordship may kindly have a glance. That is at annexure.
No, I am talking about what is the
Those read petitions, some of those read petitions, exactly the same conclusion given by the learned single judge here. The same conclusion has been given by our court also in another coordinate bench. And that is annexure 6. Your lordship may kindly have a reference, which I have also annexed. That, yes, your lordship may kindly have a glance.
We'll see too.
Yes, my lord.
Lord has ensured that 36